Morning. Thanks very much, everyone. Just to stress, what I'm doing here is absolutely not taking a side either way on what the appropriate future for the Irish constitutional provision on blasphemy is. What I want to do is simply explain how the relevant term found its way into the Constitution, what it's likely to mean in practice, and in doing so to explain how the old law of blasphemy developed up to the point where it currently is, both in the Constitution and also in the 2009 Defamation Act. When the Constitution was promulgated, it was perhaps unusual insofar as Western European constitutions are concerned that it specifically listed a crime. Constitutions, to my mind, are about setting up the grounding ideology of the state in terms of how the political structure is going to work and in terms of the rights which should be protected for citizens. And it was unusual that it would contain a crime within a clause which protects freedom of speech relating to the publication, amongst other things, of blasphemous material. President De Valera was asked at the time, what did this crime entail? And he said, and what value this is perhaps uncertain, but he said that it would simply reflect the existing common law position on blasphemy, and therefore that the crime of blasphemy within the Constitution would be the same as the crime of blasphemy as it existed at common law. In fact, there was relatively little controversy at the time the clause came into the Constitution that it would be there, and the only sort of significant commentary on it at the time came from one individual who said within the political system that the only difficulty with the constitutional provision on blasphemy was that it wasn't actually stern enough. So there was no suggestion that it shouldn't have been there, or no particularly prominent suggestion that it shouldn't have been there. Rather, the criticism was that it wasn't in fact harsh enough, and that there were certain forms of blasphemous speech which would get through the cracks in the constitutional clause, so to speak. In any event, if President De Valera was correct and the constitutional crime of blasphemy is the same as the common law crime, we have to consider what the common law crime actually entailed at the time. And one of the problems which has bedeviled the operation of blasphemy law in all religions and in societies is actually the business of defining what blasphemy is. But I think if you look at the three major monotheistic religions and their view of blasphemy, you get one common theme, which is that you're dealing with something which is an attack. And more importantly, perhaps, you're getting an attack not on individuals, because there's plenty of laws which can protect individuals in respect of sensitivities, whether they're racial or religious or political or whatever. What you have here is an attack on the sacred. Whether you're looking at the biblical account of the trial of the founder of Christianity for blasphemy, or whether you're looking at other reactions, particularly contemporary reactions in the Islamic world, you're dealing with something which is an attack on the sacred. It is, in other words, the speaking or the publishing of unacceptable magic words. And there is something, I think, if you look at the cases and if you look at the sort of the doctrinal treatment of this issue within religions, there's something almost mystical and mystically unacceptable about blasphemy, because it's taking on a concept. One legal philosopher wrote, and I think it sums it up nicely, that to be over-familiar with anyone is rude, but to be over-familiar with God is the ultimate in bad manners. And I think really this explains the reason why people of religious sensitivity object to blasphemy, on the grounds that it is dealing in an irreverent fashion with something which shouldn't be the subject of such irreverence. I think you get the same reaction in Germany to the concept of Holocaust denial. It's the idea that you're saying something which simply shouldn't be said. And yes, individuals will be wounded, but ultimately that's a byproduct of the worst thing, which is the saying of the unsayable. Now, insofar as the legal position is concerned, the common law of blasphemy developed through the English courts. And to my mind, the crime was mangled by virtue of the fact that the courts, for a period of about 400 years, used different justifications to explain the blasphemy laws, none of which came back to this central concept of irreverence being targeted by virtue of the fact that it was irreverence. So when the common law courts first took over the crime of blasphemy, and at this time Parliament in England was really concerned because there was all sorts of natural disasters happening, Great Fire of London and the Plague, and the only logical explanation that they could come up with as to why these events were happening was because God was angry because there had been so much irreverence published, bad books. And so God was smacking society in a particularly tough way. And therefore, originally, the blasphemy statutes were a sort of form of social self-defense, that in order for God to stop punishing society, it was necessary to stop annoying God. And therefore, we're going to target the blasphemous books because that's a good first point. The courts never really adopted this mentality, which was obviously unprovable either way. I have no idea whether God is in fact likely to punish society by virtue of the fact that these books are being published. I couldn't know. It quite possibly is correct. Who knows? Unfortunately, I don't have a direct line to God, so I wouldn't know that. The courts took that approach because it was simply unsustainable as an argument. And so for the first 200 years of the common law offence of blasphemy, the rationale behind the law was quite simply that the Church of England was the established church. It was part of the law of the land. If you targeted the Church of England either for scurrilous treatment or simply for denial of doctrine, that is to say, denying that God exists or denying the truth of Church of England doctrine, you were committing a form of treason because you were undermining the law, because the Church of England was part of the law. So what you had for about 200 years was three things of significance. First of all, even respectful denial of the existence of God was a form of blasphemy which would be punished. Secondly, the punishments tended to be really severe. I mean, you're talking people being put in the stocks and branded with the letter B in their tongue because what they were doing was regarded as so awful and so heinous. And thirdly, you were getting books and publications, especially at the latter part of this time, which were of genuine social importance, but which were being targeted because they undermined the Church of England and therefore undermined the law of the land. Now, by the end of the 19th century, this proposition, this idea that you needed to protect the established church as part of the law of the land from denial of doctrine, had become itself unsustainable for a variety of reasons which don't really concern us. But you started to see kind of champions of liberal philosophy and free speech activists saying, this is outrageous, it's unacceptable. So by the end of the 19th century, and particularly for our purposes, in a decision of the House of Lords in 1917, it became quite clear that now the new blasphemy law wouldn't be aimed at protecting the established church, it would be aimed at protecting individuals in respect of their religious sensitivities. And what this meant was, first of all, that mere respectful denial of some religious tenet couldn't constitute blasphemy in that sense. Rather, you had to have something which was scurrilous, really, really offensive, and likely to offend religious sensitivities. Secondly, and this is more speculative, because previously the law had been grounded on the need to protect the established church, the courts had been clear that it was only blasphemy against the established church which could be a crime. In other words, as one judge said, you could libel the whole Roman Catholic Church without any difficulties, provided only you didn't touch on Anglican doctrine or Church of England doctrine. Now, to my mind, if the law from the beginning of the 20th century was about protecting religious sensitivities from being really offended, then there's no reason not to extend that protection to all religions. But in 1991, in a case involving Salman Rushdie's book, The Satanic Verses, the English High Court said, no, well, actually, still the law only deals with blasphemy against Church of England doctrine, which was, I think, a surprising and I think probably an inaccurate conclusion. Now, on that basis then, what does the constitutional crime prohibit? If President de Valera is correct, it prohibits only those forms of offensive speech which are likely to have a genuine impact on the sensitivities of believers. And in order for something to have a genuine impact on the sensitivity of religious believers, it must of necessity be scurrilous and grossly outrageous. That was the position by sort of 1960, and a couple of developments are significant insofar as the law is concerned since that time. First of all, the 1961 Defamation Act, which is the statutory precursor to the new law, which contains a crime of blasphemy. The 1961 Act didn't actually have any law defining what blasphemy is, but it did create a procedure whereby one could take a private prosecution for blasphemy. You have to appeal or apply to the court, rather, for leave to bring a private prosecution. But it was really quite remarkable that one could actually, as an individual, say, I'm prosecuting you for a crime. Secondly, in 1991, the Irish Law Reform Commission reviewed the issue of blasphemy. I think it did so very coherently and very completely. It recommended the abolition from the Constitution of the reference to blasphemy, but also said, look, this isn't exactly a clause which is having much impact in practice. It would be a waste of money to hold a separate referendum simply to get rid of the crime of blasphemy. Therefore, the best thing to do, if it's going to be abolished, is to tack it on a day when you're having another more important referendum. Thirdly, the European Court of Human Rights on 3 occasions dealt with the crime of blasphemy, from prosecutions 2 in England and 1 in Austria, where there were challenges to the existence of blasphemy laws, challenges based on claims of free speech, and on all occasions the European Court of Human Rights found that there was nothing objectionable insofar as the convention right to free speech is concerned. There was nothing objectionable about the existence or operation of a blasphemy law. Now, one would have to say that traditionally, when you're dealing with something which is religious or connected to sort of morals, the European Court of Human Rights gives a very significant discretion to member states as to whether or not a law is acceptable. And I think in all of these cases, a very significant discretion was given to the relevant countries, and the court more or less said, well, look, if you want to have a blasphemy law and if you've got those religious views, that's your own business, go for it. Fourthly, major development, although it's slightly later, it comes at the end of the 20th century and persists until 2011, is that the Organization of Islamic Cooperation, formerly Organization of Islamic Conference, which is the second largest international group in the world after the United Nations, it attempted and successfully on a number of occasions to have resolutions passed through the United Nations prohibiting what it termed defamation of religion and calling on states to combat so-called defamation of religion, attacks on religion. And it was grounded on concerns with human dignity and incitement to hatred and so forth and so on. Since 2011, the United Nations has moved away from this proposition, but it still is relevant in trying to understand the global, and indeed with the increasing Islamic population in Ireland, the national perception of the relevance of a blasphemy law. Most importantly, though, in terms of the constitutional crime, in 1999, the Supreme Court dealt with a case called Corway, which was an individual seeking leave to bring a private prosecution for blasphemy. In the High Court, the judge had said, well, if you're going to get leave to bring a private prosecution for blasphemy, you need to show the publication is likely to cause a breach of the peace. This isn't going to happen in this case. I'm not granting you leave. The Supreme Court, on the other hand, took a different view and said, we don't know what blasphemy means. It hasn't been defined by the legislature, and in the absence of a definition, we can't apply the crime. which was, I think, a fairly extraordinary admission for the Supreme Court to make, that a word in the Constitution was too difficult for it, and therefore it wouldn't be able to apply it, particularly as the court in that case managed to conclude that the relevant publication wasn't blasphemous, which is something of an achievement if they weren't able to define what blasphemous meant. Nonetheless, what this did was effectively to render the crime of blasphemy a dead letter, because the Supreme Court was effectively saying, okay, we have this constitutional crime, we know that there is a crime of blasphemy because the Constitution tells us this, and that's an important point to bear in mind. It doesn't say that you can have a crime of blasphemy. It says that blasphemy is a crime which shall be punishable by law. It's mandatory language. Nonetheless, the decision in Corway effectively meant that the constitutional crime of blasphemy couldn't be applied. Finally, then, in 2009, the new Defamation Act was coming in. It was going to replace the 1961 Act and therefore remove the existing statutory procedure for prosecuting blasphemy. The decision was taken that in order for the new legislation to be constitutionally acceptable, it would need to make some provision for blasphemy. In addition, the legislature had the voice of the Supreme Court in the Corway case in its ear, saying it's up to the legislature to define the crime. And so the legislature set out a definition of what blasphemy would entail. And it entails the publication of grossly offensive material in respect of which religious sensitivities would be injured. What it also does, I think, the 2009 Act, is it makes it so hard to operate the law, in the sense that there are very, very strong defences to someone who's charged with blasphemy, and also the definition of blasphemy is so tightly drawn, that I think the 2009 Act effectively kills off the crime, which is ironic because it creates a statutory statement of the crime, but at the same time makes it so difficult to apply that, to my mind, it's effectively unenforceable. And obviously, there was huge criticism in respect of this. So that kind of summarizes the position. What you have is a situation where the Constitution demands that there be a crime, where almost certainly the constitutional crime of blasphemy is about the publication of grossly offensive material, which will impact negatively on religious sensitivities. And the 2009 Defamation Act fleshes that out, albeit in a way which means that the crime is going to be very difficult to apply in practice. I want to make just one final point, if I may, and it's simply this. I think, and I've studied widely in this, and I've looked at the arguments which are made, particularly by those who would oppose the existence of a crime of blasphemy. And I think it's fair to say that some are drawn with greater levels of analytical depth than others. And I think some of the arguments that are made tend to be fairly weak in practice and a little bit devoid of genuine critical analysis. But I would just say this. I was speaking at a conference in Oxford during the week where the audience would have been very significantly in the majority from the Islamic world. And I was talking about this issue. I was talking about laws against defamation of religion and laws against blasphemy. The overwhelming majority of the speakers and the audience there would have been in favour of blasphemy laws and would have said that the extent to which Western culture does not protect religious sensitivities to the same extent that it protects racial, sexual orientation, gender sensitivities, and so on. It said that this is something which is going to be a major barrier to relationships between the Western world and the Islamic world. That isn't necessarily something which is relevant insofar as this convention is concerned, and it's not necessarily something which is relevant insofar as the Irish Constitution is concerned. But it certainly gave me pause for thought that you have a very substantial section of the global population which would take a very different view to this than would be taken by many within the Western world and many within the Western media. Thanks very much.